I'm Neil Schaus. I'm a former DUI prosecutor, and I'm here with Michael Scafiddi, former DUI police officer, and we're now both DUI defense lawyers. Mike, today I want to talk about this issue of DUI cases in California when you have a child in the car. And we all know that we have some of the harshest DUI laws in the country here in California, but how does that change? How is it different if you get caught drunk driving and you have a child in the car with you?
Well, what we have seen recently in a lot of our cases is if there's a child under the age of 14, the district attorney can charge an enhancement of child endangering in regards to a DUI. So for example, if someone's charged with a DUI and there's a child under the age of 14 in the car, they can add an enhancement on the 23572 of the vehicle code, which could cause extra time in jail for the person if they're so convicted.
So it makes it like a DUI plus. It just makes the potential penalties greater.
Correct. That's and they term it as an enhancement for that in that regard.
But it can get worse, right?
It can, and we've seen this throughout the state, and this is clearly the new trend by prosecutors, is at any given opportunity to try to file it as a separate charge, a different count, under 273A or child endangering of the penal code. And the problem with that people will face is that could be a misdemeanor or felony. And as a felony, if you were convicted of that and you received the highest sentence allowable, you could serve up to 4 years in state prison on that allegation. And there are the consequences, being put into a child index, child abuser index, that will remain for you for the rest of your life. So those are really serious charges. Now, fortunately, as you know, Neil, we've had an opportunity to defend a lot of those cases, and they are defensible. For example, if we beat the underlying charge of DUI, certainly then the enhancement is dismissed. If we beat the underlying DUI charge, there's a great possibility that the felony 273A can either be dismissed or reduced down to a misdemeanor. It's all going to depend on the level of intoxication, what the blood alcohol level is, the circumstances surrounding the contact, certainly. If it was just minor bad driving versus some serious bad driving, all those will factor in. And we recently just concluded a case like that out of our Inland Empire office in San Bernardino.
And I want to ask you about that, but just to clarify for our viewers, what you're saying is that normally, if you get a simple DUI, let's say a first-time DUI, that's just a misdemeanor, right?
Correct, it is.
And usually you don't serve any time. I mean, sometimes there might be a few days of work release, but usually no time on a first-time DUI with no enhancements, right?
That's absolutely correct.
But you have a child, you have a 5-year-old, a 3-year-old, a baby in the car, they can charge a felony where you can be looking at 4 years in state prison.
That's correct. And also, if they do arrest you for the 273A charge and the district attorney files that as a felony, now you're in jail unless you post bail. You wind up serving some significant custody time if you can't post bail as you litigate those issues.
So it makes it just a far different case in terms of the ramifications for the driver.
It makes a completely different type of case for the consequences as well as the way you defend them.
Now, you've had a lot of success, and we've had a lot of success representing clients who are charged with the enhancement and also child endangerment in this situation. And you have a recent case, right?
We do. It was a case out of the Inland Empire office, out of Colton, and our client was a 35-year-old woman who had her 5-year-old daughter in the car with her. She was stopped because someone had called in of a possible DUI driver. She was actually stopped by a Colton police detective. She was arrested for DUI and felony child endangerment. Her blood alcohol level was rather high, 0.18. But we learned through our independent investigation that the reason she was there at that exact moment, she had been home, she had been drinking, she had not expected to leave that day. Her boyfriend came home and beat her up. She was concerned about calling the police because in the past she had been the victim of domestic violence and they hadn't done anything for her. So she felt that the only thing she could do is leave her home and drive to her sister's house. She was en route to her sister's home when she was arrested. We argued to the DA that this was a necessity defense, that if she remained, she could have been seriously injured or killed, or her child could have been seriously injured or killed.
So she wasn't running errands, she wasn't partying, but she had some urgency to be driving at the time.
That's correct. And because of that, we were able to convince the DA to dismiss the felony 273A, dismissed it as a misdemeanor. We pled her to one single count of a first-time DUI, and she received credit time served because she had spent 3 days in custody before she was able to bail out. Overall, a great resolution for her. And one of the best parts about doing cases like that, when you have a good outcome, is her and her daughter have been reunited. They're doing well. She's separated and divorcing that person who's abused her, and she's on her way to having a good life.
So here's a woman who had a .18 BAC, was potentially looking at a felony conviction, being a felon for life, and serving up to 4 years state prison. And in the end, she got a simple DUI, misdemeanor, no additional jail time.
That's correct.
By virtue of having a good DUI defense lawyer.
I believe so.